दोस्तों इस क्लास में आपको डिक्टेशन दूंगा मैं 100 WPM पर 600 वर्ड्स की डिक्टेशन है, आपको डिक्टेशन में प्रोवाइड कर रहा हूं। बी रेडी फॉर इट। The challenge in the present appeals is to an order passed by the High Court of Madhya Pradesh whereby the revision filed by the appellant or nominated officer of the Hindustan Unilever Limited was allowed. However, the matter was remitted back to the trial court to revisit the evidence adduced by both the parties. So far, it relates to the appellants Nirmal Sen and the company. Brief facts leading to the present appeals are that a complaint was filed by Inspector of Food and Health on the basis of a sample taken in respect of Dalda Vanaspati brand ghee manufactured by the company in terms of the provisions of the Prevention of Food Adulteration Act 1954. The sample of Vanaspati ghee was taken from the godown of Lipton India Limited, which was found to be adulterated as the melting point was found higher than the normal range. Initially, the complaint was filed against the directors of the company as well as that of Lipton India Limited. In terms of the directions of this court, it appears that the learned trial court passed an order absolving the directors of the company and the prosecution was ordered to continue against the appellant. The said order is not on record, but it appears that no proceedings were continued against the company inasmuch as it has 4 accused. A complete reading of the order passed by the trial court does not lead to an inference that the company was represented at any stage during the course of trial. It is to be noted that in the aforementioned judgment there was no order passed by the learned trial court to convict the appellant company of any offence. The appellant contested the proceedings and was convicted by the trial court. With the aforesaid discussion, the learned additional sessions judge affirmed the conviction of the nominated officer, but the conviction of the accused was set aside and they were acquitted. The High Court in its order noticed that if the company is acquitted of the charges, the said benefit will also directly go to the nominated officer. A glaring and patent defect in the judgment of the trial court as well as in the judgment of the appellate court was observed by the High Court. Thus, the conviction and sentence passed against the appellant, being a nominated person of the company, was set aside and the matter was remitted back to the trial court for passing fresh judgment. The learned senior counsel for the appellant company raised an argument that the company was not convicted by the trial court. Therefore, the High Court in revision could not have passed an order of retrial, more so when the company was not given any notice of being heard. In terms of Section 6 of the General Clauses Act 1897, unless different intention appears, the repeal of a statute does not affect any investigation, legal proceeding or remedy in respect of any such right, privilege, obligation, liability, penalty, forfeiture or punishment, and any such investigation, legal proceeding or remedy may be instituted, continued or enforced, and any such penalty, forfeiture or punishment may be imposed as if the repealing act or regulation had not been passed. The question as to whether penalty or prosecution can continue or be initiated under the repealed provisions has been examined. In another judgment, the assessments were completed under the Income Tax Act 1922 after the Income Tax Act 1961 came into force. There was search on the premises of the assessee. The revised returns were filed after the Income Tax Act 1961 came into force. दोस्तों इसी के साथ ये डिक्टेशन फिनिश होती है। पूरी उम्मीद है आप लोगों ने इसे अच्छे से लिखा होगा। मेहनत लगातार करते रहिए, बहुत अच्छे मैटर्स तैयार करें आपके लिए, आप बस लिखते जाइए। आपसे मुलाकात करता हूँ अगली क्लास में अगले ट्रांसक्रिप्शन के साथ। तब तक के लिए बाय बाय, टेक केयर।